Good afternoon, everyone. My name is John Gallo. I'm the CEO and Executive Director of Legal Aid Chicago. Welcome to our fifth session of our series called Finding Solutions, Legal Aid for Our Most Valuable Populations. Today's session will focus on the unique needs of survivors of sexual assault and how legal aid can help. Now, to get started, I'll turn it over to our host for today's session, one of our board members, Jared Heck. Jared is a partner at one of our longtime law firm sources of support, the Catton firm. So Jared, turning it over to you.
Thank you, John. First, I want to say I'm honored to be here as a representative of the board of directors and as a partner of my firm, Catton. Speaking for Catton, we are very proud of our longstanding support and commitment to Legal Aid Chicago. Beyond our financial support, I'm proud to say that in the past year, more than 50 Catton attorneys have assisted on various pro bono projects with Legal Aid Chicago, which I find particularly impressive in light of COVID. Many of those volunteers participated through the Day Diego Clinic, which has gone virtual during COVID. And I personally consider that clinic the crown jewel of our entire pro bono program at Catton. In fact, this month's clinic takes place this afternoon, where I believe our entire summer associate class will be participating, and I will also be participating, and I always consider it incredibly rewarding to do so. With that said, I'm going to turn it over to our speaking panel for today. We are joined by Maria Bellata of Resilience, Micah Held, who's a staff attorney in the Children and Families Practice Group of Legal Aid Chicago and a former pro bono partner of me personally on a very invigorating divorce appeal that we handled a few years ago. Additionally, we have Bharti Pillai, a staff attorney in the Immigrants and Workers' Rights Practice Group, and Teresa Sullivan, a supervisory attorney in the Children and Families Practice Group, who I will now be turning over the mic to.
Thank you so much, Jared, and thank you to you and Catton for your support of our work. Really appreciate it. Thank you everyone for being here today. I am just going to give you a quick overview of what we're going to cover throughout this presentation. Really look forward to sharing our work with you and also taking your questions at the end. So today we're going to talk to you a little bit about who we serve when it comes to sexual assault survivors. We're going to talk about the unique needs of sexual assault survivors. Certainly there are many. We'll cover a few that come up frequently in our cases. I'm going to tell you about the CLASP project, which is a special project that we have here to serve sexual assault survivors in a comprehensive way. We have a special team of attorneys and a dedicated paralegal to serve survivors. Then you'll hear from our wonderful partner agency, Resilience, Maria Bellata, who Jared introduced to you. And finally, we'll spend the bulk of the presentation talking with you about the legal relief available to survivors of sexual assault. Again, not everything, but we're going to give you a highlight of the work that we do and the kinds of relief that we're able to achieve for survivors. First of all, just wanted to give you a brief overview. Basically, we'll serve any survivor who has civil legal needs that fall within Legal Aid Chicago's priorities or abilities. But we do have a particular focus on non-intimate partner assault, adolescent and teen victims. You'll hear from Micah Held later, who has a real particular specialty and ability to work with teen victims and their families who are navigating the civil legal system, as well as low-wage workers. And you'll hear from Bharti, who will give you some highlights of our work on the employment law side of things. And then we'll give you a little bit of a sense of the other practice groups too, in which we do not practice, but in which we have wonderful colleagues who do. I want to talk to you a little bit about the unique needs of sexual assault survivors and why would we have a particular project? Why do we have people who specialize in serving these survivors? First of all, we know that with sexual assault survivors, as with some domestic violence survivors, there's a lot of feelings of self-blame. What could they have done differently to avoid having become a victim? What should they have said or done, et cetera? Obviously, part of our work and hopefully the work they're doing with their trauma therapists, for instance, at Resilience, is to unravel that, is to help them understand, like, they did not do anything to cause someone to harm them. And so sometimes we have to get back past that barrier where people are like, oh, I don't know if I deserve, help, if I deserve justice. I did X, Y, and Z, and that led to this happening. No, so part of our job is to disrupt that thought, that pattern of thought. It's also really difficult to testify about sexual assault. First of all, it's something that almost always happens in private. It's a intimate and very horrible violation. Second of all, trauma can affect the brain in a way that makes it somewhat very difficult, in fact, to sometimes recount what has happened. Trauma can make it so that someone can't remember step by step what they went through, as when they were being assaulted, or ahead of time, or afterwards. And so we oftentimes are helping people kind of piece back together the story, which can be painful, but sometimes, necessary to get the story in a place that then can make sense to a judge. And so the difficulty in testifying, comes both from just the shame and the guilt and the doubt and just the very intimate nature of these harms, and also this trauma that can affect the brain and the way that people remember what has happened to them. We also find challenges, I do, and Micah, especially in our work serving teen survivors. Oftentimes teens and parents differ about the strategy that they want to take. Sometimes parents want us to be really aggressive in going after the perpetrator of the harm. And the teen might just say, no, I don't really want to pursue a protective order, but I do need your help in getting some education accommodations, something that can keep me safe from my abuser at school, or, something that can keep me safe at work, etc. Survivors also face a criminal legal system that is often unfortunately hostile to them. They have a hard time being believed because, again, it's hard to bring proof other than very credible testimony that something has happened to police officers. Sexual assault victims get dismissed oftentimes by police, by prosecutors. Not saying there aren't amazing police officers, amazing prosecutors out there doing wonderful work, but the system itself often fails survivors. And it sometimes fails survivors because survivors themselves have a hard time remembering what happened. And so the criminal legal system is based on being able to prove something with quite a bit of certainty. And so there's a gap between what the survivor is able to provide to the prosecutor, to the police officer, and what they need in order to prosecute. So sometimes survivors are coming to us and they have just been really disappointed in the lack of action or lack of assistance that they expected to receive when they when they bravely told their story to a police officer, to a prosecutor, etc. So these are some of the challenges, some of the needs that survivors come to us with, certainly countless other things that we're dealing with along with trying to litigate their case. I want to tell you a little bit about our special project, the CLASP project. It stands for Comprehensive Legal Assistance for Survivors Project. We have been doing this project since 2014, and we have a team of attorneys from the Children and Families Practice Group, Micah and I. We have Barthy in the employment group. We have immigration attorneys. We also have housing attorneys. We have a special paralegal, and then we have folks who consult with us from the education law, consumer, public benefits, who are not funded by whatever grant it is, by the CLASP grant, but provide assistance when we are trying to serve survivors' civil legal needs. What's wonderful about this project is that we all stay in really close touch with each other when we are each serving the same survivor. We'll copy each other on our case notes. We have a monthly meeting during which we talk about progress on cases or recent challenges, recent achievements, etc., so that we're really all in sync about our practice here to serve survivors. And I think that's one of the wonderful things about Legal Aid Chicago is our ability to serve clients in a variety of civil legal needs. I think this project steps it up to that next level by keeping us in close contact, by having us meet monthly to stay in sync so that we can provide the best service possible to survivors. And then, you know, a very important part of this project is our partnership with Resilience. You'll hear from Maria Bellotta. Resilience used to be known as Rape Victim Advocates. You may know of it by that former name, but they provide you'll hear from her, but they provide comprehensive services, therapy, medical advocacy, legal advocacy. You'll hear from Maria about, and importantly, they are our partner on this class project, meaning they'll send clients to us. We sometimes send clients to them. We have a direct link between the organizations so that survivors don't have to navigate their way into Legal Aid Chicago on their own, but can do it with the assistance of an advocate at Resilience. Today, we're going to present you with two hypothetical clients that these will be kind of the thread throughout the presentation to help you understand the work that Legal Aid Chicago does to serve survivors. You'll kind of see how we can help with, you know, employment, with protective orders, with housing, etc., through the lens of these clients. So we have Miranda. These clients are not our real clients, but a lot of these details have come from various different clients so that you can understand the scope of our work. So we have Miranda, who's a teenage Latina. She attends Chicago public schools, works at a fast food restaurant. She's undocumented. This woman was raped by her coworker at work, and her school is right next door to her workplace. So Barthy and Micah and I will refer back to Miranda, as will Maria, when we talk about the kinds of services and legal relief that we can provide to her. Then we have Beverly, a Black woman in her 50s, who's a subsidized housing resident, who was assaulted by a handyman on staff at the housing complex. She doesn't remember the details of the assault. This can happen if someone is drugged, or the trauma, again, can cause that. The building staff, she reported him to the building staff for what he did. She knows he hurt her. He's continuing to hurt her. He's slashing her tires, calling her repeatedly, and the building staff is doing nothing. They're not responding to her or helping to keep her safe. And then she also received a medical bill for treatment after the assault, something else that we can help with. So we'll refer back to these folks. Maria and Micah and Barthy will call them out and give the detail that they're talking about. But these are the folks that we're going to use to help you understand our work. And then I am delighted to introduce Maria Bellotta, Director of Advocacy Services at Resilience, who is our one of our main contacts and partners at Resilience on this class project, and also runs a large portion of Resilience's fabulous work to serve the needs of sexual assault survivors and empower them and help them in their journey to healing. So Maria, I'll turn it over to you to tell us about your great work. And thank you again for being here.
Oh gosh, thanks, Teresa. I appreciate you having me. I appreciate the opportunity to talk to folks about some of the work that we do and how we partner with organizations like Legal Aid Chicago to support survivors. So I want to look at some of these scenarios that Teresa has presented with us. And I want to first think about the young client, the teenager, Miranda, a Latina young woman attends Chicago Public School who was sexually assaulted by a coworker at a party. So what are some of the things that Resilience would be able to support a client like Miranda with? What you're going to hear me talk about is some overlap in the wonderful services that our agency provides, along with the work that you all do at Legal Aid Chicago and some of the pro bono attorneys as well. What I'd like you to think about is that certainly not every survivor, despite that being our wish, has access to an attorney. Because of organizations like Legal Aid, where we're bridging the gap where we can. And so, but there still remains folks that aren't able to find the representation they need. So I'm going to talk through some of the things that an advocate would be able to assist with, or a rape crisis agency like Resilience would be able to assist with, in addition to some of the work that you all are doing. So of course, the primary one that's going to come to mind is going to be our crisis intervention services. So every single advocate on our team has minimum 60-hour training. And in addition to being trained as an advocate in all the rights of survivors, they're also trained crisis counselors. So we can provide that crisis intervention in the moment that someone connects with us and needs support. The primary means in which we provide the crisis intervention is through our medical advocacy program. We partner with 17 hospitals in the Chicago area where these facilities will contact us when a victim of sexual violence is at the hospital to receive care. The hospitals will reach out to us and we will send out an advocate in person to provide medical advocacy, legal advocacy, and crisis intervention. So that person is there for the survivor. Of course, we don't work with the hospitals, we don't work with police. So we're really in a unique role to advocate for someone within these systems as an outside party. All of the services that we provide at rape crisis centers are legally confidential and they're free. So we will show up on site to offer support to that survivor. What does that support look like? We're really well trained in the rights of survivors. And in Illinois, we have pretty good rights of survivors in the books in terms of the kind of care that a hospital must offer a survivor. However, not every provider has been trained in those rights. So the advocate's there to provide support throughout the medical exam at the hospital. The advocate is there to provide support throughout the forensic exam. Illinois is still a state that does not guarantee that a special nurse, you may have heard the term a SANE nurse, also known as a sexual assault nurse examiner. Illinois is still a state that does not guarantee treatment by a SANE. Many times a survivor might go into a hospital and you have a generic, wonderful ER nurse who's been handed a kit and told to go do it, and they've received no training on it. So the advocates can help bridge that gap in addition to providing emotional support throughout that process to that patient. So we're there to hold hands with that patient if they choose to, and we're also there to help support that nurse who might say, hey, I've never done a kit before. What do I do with this? In addition to that, we're there to assure that the patients are offered the treatment that is extended to them under state law. Some of that treatment is going to be emergency contraception, so medication that someone could take to prevent pregnancy, medication that someone could take to prevent HIV or STIs. So those post-exposure prophylaxis patients have a legal right to. And we want to make sure that we're also offering options related to pregnancy. Someone might be coming to a hospital because they already are pregnant, and maybe there's a complication with the pregnancy and they disclosed that that was as a result of a sexual assault. So our role there is to make sure that the treatment options, the rights of the patients related to everything that's afforded to them in the hospital is really being honored. That also includes our role in survivors' choices around engaging with the criminal justice system. So survivors have choices to do that. Law enforcement can be called to a hospital. An advocate is there to make sure that no one is being forced to do anything they don't want to do. One of the really cool things about our work, I think, is that our work is survivor-led. Our advocates do not have an agenda. We don't exist to make sure that there's more police reports and more people go to jail. That's not our agenda. Our agenda is to support people in healing. And so we do that by supporting every choice they make. Speaking of healing, we can also support survivors by offering free trauma therapy services to them. All of the trauma therapists at our agencies are trained in a variety of modalities. We have art therapists that work with us. We have a dance movement therapist that newly joined our team. We have folks that are certified in trauma healing yoga practices. And recently our team's all been certified in EMDR. If you're familiar with that, it's a type of therapy that's specifically useful with trauma survivors. The advocates are also going to support someone like Miranda in thinking about safety planning. What does safety planning look like? So we know that Miranda is a teenager. She works at a fast food restaurant. She's undocumented and she's been harmed by a coworker. So she might have concerns about what does it mean to feel safe in this environment. where she's working with someone. So we'll talk through safety planning. We can offer protective orders. And in fact, we can petition for those protective orders through the statute. Advocates can assist with that before someone is able to get connected with an attorney. So advocates can provide that support. We also help folks with things like Safe Homes Act, which you'll hear about a little bit later in the presentation. And that would be remedies around potentially terminating a lease early or getting an emergency lock change. We can also cover costs for. We also support survivors through employment accommodations or considerations, whether that be time off or safety planning with the employer around things that need to support that survivor to stay safer. And similarly with educational considerations, we said Miranda attends Chicago Public Schools. Maybe Miranda needs some time off to see a therapist, et cetera. We can work with them to establish those accommodations under the rights of survivors. And then, of course, we can make referrals to the wonderful pro bono attorneys like those at Legal Aid Chicago and some of the other partner agencies. When we're working with someone that needs that higher level of legal care, we can make those referrals to provide that support. So let's look at our second scenario, which was the one you saw with Beverly. Beverly was the 56-year-old woman who lives in subsidized housing, and she was sexually assaulted by a handyman. Some of the same things, of course, might come into play. We offer that crisis intervention, medical advocacy if Beverly chooses to go to a hospital. We're going to do some safety planning with Beverly. What does it look like to remain safe in your home? And that might involve things like thinking about those protective orders, which you'll hear about, or tapping into the Safe Homes Act, which again, you'll hear about. Of course, we're going to offer Beverly also those trauma therapy services, which could be individual therapy, group therapy, where we run support groups at times that are identity-based. So in our scenario, I believe Beverly was an older Black woman. And we have run support groups that were specifically for Black women survivors of sexual violence, because our work aims to be intersectional and sees the full identities of the clients that we served. We also heard in Beverly's scenario that she received a medical bill for treatment after the sexual assault. And you'll learn today that that's against the law in Illinois. So we have protections in Illinois that sexual assault survivors should never receive a bill for the care that they're receiving. And so our advocates can also assist with rectifying those bills. I'd like to think about our partnership with the attorneys often as you all have plenty to do on your plate. We can take things on, and oftentimes we're able to resolve things, let's say like this medical bill. But if we can't resolve it, we're going to call in the big guns, right? So we'll call in our attorney friends and make that referral to the attorneys and say, look, I've been trying to work with the hospitals and they're not resolving this billing. Now we need to escalate it and get more hands on board. So these are just some scenarios or some ways that we may be able to support these two clients. In this next slide, you'll see kind of an overall kind of a bird's eye view of resilience services. I've talked to you about our medical advocacy services, our legal advocacy services, and our trauma therapy services. But I do want you to know that we also are engaged in education and training work. So when we think about comprehensive services, we don't want to be an agency that is only responding to violence, right? Medical advocacy, legal advocacy, trauma therapy, those are services for someone who has been harmed and they need and deserve support. And that's important. But we want to be an agency that's also committed to eradicating sexual violence and ending the cycle of violence in our community. And that's where our education and training team comes in. So we have educators at the agency that engage with young people. And we even start those trainings as young as kindergarten. And we are with folks throughout kind of their education. We're in Chicago Public Schools, where we talk about healthy sexuality. We talk about what consent is and isn't. We talk about gender roles and how those things contribute to a culture of violence, et cetera. So we also do this engagement, not only with schools, but with community groups. And we train professionals like yourself to respond to survivors so that we're kind of hitting all the forefront of the spaces to create safer communities for survivors and work towards a future free of violence. So that's what I got on my end. I'm going to pass it back over to Teresa.
Thank you, Maria. And now you can see why we feel so fortunate to have Maria and her team as partners. They're just doing excellent, excellent work. And I will say, just as an anecdote, we had a client who participated, I think, in your dance therapy and then another like special affinity group therapy. And that, you know, we got her legal relief, but that's what really got her on the path to healing. And so that the work you do is so powerful, and we're just so grateful to have you as our partner. We also have other, you know, partner agencies as well who are doing wonderful work, like the YWCA and DV advocacy groups, and we count Resilience among just some of our very best partners. So thank you so much, Maria. I'm going to just lead you through a little bit what this legal relief might look like for survivors, and then you're going to hear from Micah and Bharti about the specifics of these. So first, we're going to talk a bit about personal safety. How can we help from the legal aspect someone to obtain or attain safety? First, we can help with obtaining protective orders. This is something that you know, we do every day. We have, you know, 12 attorneys who do protective orders as part of their work here at Legal Aid Chicago. We also can help them if they have related family law needs. So if our client needs a divorce or what's used to be called a custody case related to the legal problem, we might stay on with the client after we do the protective order to do that case as well. We have some specialists in education law, and especially specialists in Title IX, so rights of students who have been victims of sexual assault. And then finally, we also have occasionally done work using the Gender Violence Act, which allows us to bring a tort claim against the perpetrator of violence if it's related to, you know, to our other cases that we are doing for the client. Then you'll hear about employment law from Bharti. You'll hear about how we can help those who are victims of retaliation, how we can help those who are trying to achieve safety in the workplace, and those who need to take leave to meet their medical and or legal needs as it relates to their sexual assault. So there's a special law called VESA that allows them to take leave in order to obtain the services that they need that have arisen from their needs as a survivor of sexual assault. And you'll hear a little bit more about that from Bharti. Then we will touch on, but we won't go too in depth on, immigration law, public benefits in our consumer work that we do to help survivors, and also our housing practice group. We do not, the three of us do not practice in those areas, but we are fortunate to have very talented colleagues who do, and we just want to give a little shout out to them for the wonderful work that they're doing to support our shared clients. So now I need to share the CLE code with you, and I'll say it out loud twice. It is 962120. Again, 962120. And now I'm going to turn it over to Micah Held, who I have the pleasure of both supervising and being a friend of, and I look forward to you hearing from her about the fantastic work that she is doing to serve survivors of sexual assault. This is really her specialty area when it comes to the work that we do. So Micah, take it away.
Thank you so much, Teresa. We're going to be talking a little bit more about what types of relief we get for our clients in the realm of family law and education law specifically. And we are going to come back to the hypothetical clients that Teresa had introduced earlier. And the first thing we're going to talk about is protective orders. That does make up the bulk of our practice for sexual assault survivors. In Illinois, there are 3 types of protective orders. And I'm only going to be talking about 2 of them today, but just wanted to reference the one I'm not talking about, which is an order of protection. In order to get an order of protection, you have to have a specific familial relationship with the person who's harming you. And the 2 orders I'm going to talk about today are protective orders where you don't need that special relationship. And they're orders that are going to fit for Miranda and Beverly, our hypothetical clients. So Miranda is eligible for a civil no contact order. Both both of the two protective orders that I'm talking about today were enacted more recently than the original order of protection, the one with the familial relationship. So civil no contact orders have been around since 2004, and the stalking no contact orders have only been around since 2010. So if you remember, Miranda is the teenager, and somebody had asked this question in the chat, which we're going to take those questions at the end, but just to clarify, yes, Miranda is a minor in our example. So if you recall, Miranda is the teenage client that attends Chicago Public Schools, CPS for short, and her school is right next to her work, and she was sexually assaulted by her coworker. So she's now having to go into a place that is next to the person who harmed her. So she's eligible for what's called a civil no contact order. And a civil no contact order is any victim of sexual assault or somebody who's been sexually touched can get it against the person who did that to them. This is really helpful because before, when we didn't have civil no contact orders, if you had been sexually assaulted by somebody that you didn't have that family relationship with, you could not get protection against them. In order to get an order of protection, it needed to be a family member or somebody that you were in a relationship with to get that protection. Luckily now survivors don't need a relationship. So if you were sexually assaulted by a stranger, a classmate at school, a coworker, you are now able to get this protection. So if she goes to court, gives credible testimony about what her coworker did, she can end up with a civil no contact order, which lasts for 2 years, and it prohibits the coworker from contacting her in any way, including text, in person, or through third parties. The abuser can't contact her mom and say, give her this message. She can also protect people in her household, and then he wouldn't be able to contact the people she lives with as well. It can also prohibit people from being near your school, your work, or your home. And so she could get him prohibited from being at her workplace, which we actually dealt with an appellate case like that within a few years ago. And because they had the same workplace, the abuser appealed the civil no contact order and said, you banned me from going to my own workplace. What am I supposed to do? And the judge said that it was on the employer to figure out where, a different place, a different location for him to work, because he could not be in the same location as her due to the civil no contact order. Now, it would be a lot more difficult to get Beverly a civil no contact order, because if you remember, she's the woman who was assaulted by the handyman on staff in her public housing, and she doesn't remember the details of the assault. So assuming there's no other evidence, she's probably not going to be able to prove to a judge that she was sexually assaulted by the handyman. But she does have another option, which is the stalking no contact order. And a stalking no contact order, you have to show that there's been a course of conduct. So 2 or more incidents, that's what course of conduct means, that would cause a reasonable person to fear for their safety, the safety of a third person, or cause them emotional distress. So Beverly would be able to get this stalking no contact order if she talked about the handyman slashing her tires and calling her repeatedly. Those are 2 incidents that she can use in order to stop the continuing harassment by the handyman. And again, she wouldn't be eligible for this order of protection where you need a family relationship with the person who's harassing you. So she'll get the same remedies that I talked about for Miranda's case. If she gets the 2-year stalking no contact order, the handyman cannot have any contact with her. He can't stalk her, and you can prohibit his presence from certain places, including the housing where she lives. I wanted to shout out a pro bono attorney that I worked with recently from Freeborn and Peters, who helped us obtain a civil no contact order for a teen client who had a sexual relationship with a middle-aged manager at work. It sounds like a straightforward case, but there was a lot going on, and she did a really excellent job arguing in court and helping our client get the civil no contact order. So moving on to the parentage realm of things, we are very lucky in Illinois to have a law, and the statute is cited on the screen here, that allows women who are sexually assaulted and get pregnant as a result and end up carrying the baby to term to give them protections from the rapist. So if Miranda became pregnant as a result of the rape by her coworker and decided to keep the child, she could prevent the rapist from having any rights to make decisions about the child and contact with the child. She would still be eligible for child support from the rapist father, and the child would still have inheritance rights from the rapist father. So we don't see this come up very frequently, but when it does, we have used this statute both in an offensive stature and defensive stature in order to obtain relief for clients. We had a case a few years ago where Marco had filed a parentage case to see his 11-year-old daughter who was conceived by rape. Our client visited Chicago from another country when she was 17. He kidnapped her, sexually abused her repeatedly, forced her to work, and she got pregnant and had a child. She was eventually able to escape and ended up meeting and marrying another man, and her daughter had been brought up believing her stepfather was her biological father. So this 11-year-old didn't even know she had this other dad, let alone the way she was conceived. We ended up using this statute in a defensive posture, having to prove a rape that happened 12 years prior. And in the course of discovery, we were able to get a discovery judgment against Marco, and he chose to drop the case rather than pay the discovery judgment he owed. So that is an example of using the statute in a defensive way. But we also, on rare occasion, want to file a parentage case and use the statute to say, you know, hey, we might want child support from this person, but we don't want the rapist getting visits with the child. Finally, talking about education law, and we're going to focus on Miranda again here because she's the one in school. Before we talk about her rights, I want to tell you all about a federal law called Title IX. It guarantees equal education to boys and girls, and I'm sure most of you have heard about it in the context of sports and making sure that we have the same amount of women's teams as men's teams in sports at schools, but it also extends to protecting sexual assault survivors. And every school that receives federal funding, which is almost all schools, including private schools, K through 12, as well as secondary, have to abide by Title IX. So Miranda is unable to attend school in person because her work is right next door to her school, which causes anxiety attacks. Now, if we got the civil no contact order and he's prohibited from coming into work, maybe she feels a little bit safer. But let's say we didn't get it, or, you know, we're still discussing that option and haven't been to court yet to get that. And she needs relief now in school because she's not getting access to her education. So under Title IX, she has the right to accommodations to make her feel safe in school and to help catch her up and get her to the same place as everyone else. First and foremost, we sometimes ask for safety transfers in schools. So a student can transfer within the district to another school where they feel more safe. Sometimes students don't want to do this. Their friends are at their school or they're in the middle of their classes. They don't want to do that. In which case, the next best thing is to get a safety plan in place at school. And this looks different for every survivor. The most common thing we do with safety plans is having an adult walk with students during passing periods, particularly if the perpetrator is at the same school. Prevents harassment when they're not in a classroom with teachers. We can also get additional time on tests or work, assignments, and then another common one is time with the social worker, to the extent that, you know, each survivor is individual. You can kind of craft whatever accommodation that they need that's specific to them. Now, if the school refuses to give Miranda protections, the first thing we would do is send a demand letter to the school citing Title IX. If that doesn't work to get an investigation going or to get the accommodations that the student is entitled to, we can report the Title IX violation to the Department of Education, and that will start an investigation of the school. And the Department of Education has the right to pull funds from each school. Finally, as a last resort, we could file a Title IX lawsuit. It's a very high standard and very, very difficult to win. You have to prove deliberate indifference and that the school knew about the sexual assault. We had a case where our client Laura was sexually assaulted by 13 classmates at a CPS school. The school refused to investigate because the dean said the boys have a right to their education too. Our client Laura did not go to school for a full month because she was too terrified to return. The first thing we did upon getting involved was get her transferred to another school, but we were still having difficulty getting her accommodations with the school. In her case, she needed CPS transportation to and from school because she had been assaulted on her way home from school, and it was very scary to her to be in a public space. She also didn't want to go into gym class because she didn't want to be physically touching men in the gym class. So we ended up, there were other things too, but those were the two big ones that I remember. We ended up filing a Title IX complaint with the Department of Education, and after a 3-year investigation against CPS, the Department of Education found that CPS had violated our client's Title IX rights. It led to a huge overhaul in the way CPS responds to sexual assault complaints. You may have read the Betrayed series in the Chicago Tribune. That came out right before the Department of Education finished our investigation, and the Tribune continued to kind of put a spotlight on CPS, which also helped lead to this overhaul and changes in the way that they handle sexual assault complaints. I'm going to turn it over to Barthy now, sorry, to talk to you a little bit more about employment.
Good afternoon, everyone. Thanks for being here today. As Micah said, I am a member of Legal Aid Chicago's employment team, which is within our immigrant and workers' rights group. Our team represents clients in a range of employment matters, including filing claims against employers who violate our clients' rights to be protected against discrimination and retaliation in the workplace. So what exactly is employment discrimination? Discrimination is when an employer treats an employee differently with regard to any term, condition, or privilege of employment based on their membership in a protected category, such as race, gender, disability, sex, or religion. Harassment is based on a membership in a protected category is a form of discrimination. So sexual harassment is a form of discrimination based on sex, which is prohibited. So employers are not allowed to retaliate, also not allowed to retaliate against an employee who takes action to protect or enforce their rights to work free from discrimination in the workplace. Unfortunately, many of our clients experience sexual harassment and retaliation in the workplace. And because many of our clients are low-wage workers, they may already be experiencing imbalances in power, and having a legal representative can make a really big difference in educating our clients about what their rights are and helping them to effectively exercise their rights. All right, so what kinds of conditions do our clients face? Well, we can again take a look at the case of Miranda. So again, just as a reminder, Miranda is a young, undocumented woman working as a hostess at a restaurant, and she's being sexually harassed by her coworker on a routine basis. Her coworker routinely makes sexual comments to her, stares at her, and even brushes up against her when he passes by. These actions all are unwelcome. They make Miranda feel very uncomfortable and unsafe at work. So what kind of legal protections does Miranda have? And how could Legal Aid Chicago assist her? As I mentioned, sex harassment is a form of sex discrimination. So therefore, Miranda would have a right to be free from discrimination based on her sex in the workplace. There are a variety of laws at the federal, state, and local levels that prohibit discrimination against an employee based on their sex. First, Miranda could be protected under Title VII of the Civil Rights Act. Title VII is a federal law that protects employees against discrimination based on certain specified characteristics that I previously mentioned. And it's enforced by an administrative agency of the federal government, the Equal Employment Opportunity Commission, the EEOC. Under state law, Miranda is protected under the Illinois Human Rights Act, which is enforced by the Illinois Department of Human Rights. And Miranda could also seek protection under either Chicago or Cook County ordinances, depending on where the employer is located. So an attorney is generally in the best position to help our clients decide the best place to file a complaint. So when is an employer responsible for the conduct of their employees or harassment going on in the workplace? Well, first, the harassment, as I said, has to be based on a membership in a protected category. So that means a lot of unfair or bad behavior is unfortunately not prohibited under these anti-discrimination laws. So these laws really were created to address the specific wrong of how certain groups have been subjected to discriminatory treatment in the workplace. As we mentioned, discrimination based on sex is a protected category, so Miranda the employer would be responsible for this conduct. So next we'll want to know who's the harasser. The employer is responsible for the acts of its employees, but it also is responsible for the acts of customers or third-party vendors. Here, the harasser is a coworker and an employee of the employer, and so the employer could be held responsible for his acts. Third, does the employer know about the harassment? So in order for the employer to be held responsible for the coworker's conduct, we would want to know, what did the employer know and when did they know it about the harassment? Once an employer knows or should have known about the harassment, the employer is going to be considered to have been on notice, and they have an obligation to take appropriate corrective action to stop the harassment. In Miranda's case, we would recommend that she try to address the issue by complaining to her supervisor, or if there's an HR department, to the HR department. But generally, it's best to put a complaint in writing. Of course, that doesn't happen all the time, and it's not required. But once Miranda does make this complaint and the employer knows or is aware of the behavior, they have a duty to take appropriate corrective action to stop the conduct. On the other hand, if the harasser is not a coworker but is a supervisor, the employer is going to be considered to have notice and would be responsible for the supervisor's acts, even if Miranda doesn't make a complaint. Okay, so now that the employer, we could say, is on notice of the harassment, what does it really mean to say that they have to take appropriate corrective action, reasonably calculated to stop the harassment? Well, that does mean that the employer has some options for addressing the harassment, but the action that they take must actually stop the harassment from continuing, or at least it should be reasonable to conclude that it would stop the harassment. And whatever actions they decide to take, it can't be adverse or punishing Miranda or the person complaining about the harassment. So here, once Miranda makes this complaint, or because it's a coworker and the employer is aware of the behavior, they can investigate what Miranda's complaint is about. And based on that investigation, they can decide what steps to take. They could warn the harasser to stop the conduct, or they could transfer the harasser to another location if they have other locations. And they could terminate, but they're not obligated to terminate the harasser. The employer cannot, though, say that Miranda, you are the one who has to be transferred to another location or punish her for the complaint. Okay, so in this case, the employer actually doesn't take the appropriate action to address Miranda's complaint. And the coworker continues harassing Miranda and is actually emboldened and becomes more aggressive in the workplace, leading to him sexually assaulting Miranda at work. Miranda reports her coworker for the sexual assault to the owner, and the owner, who also happens to be the harasser's uncle, decides to fire Miranda rather than take action against the coworker. So now what legal protections does Miranda have? As we mentioned, sexual harassment is a form of employment discrimination based on sex, and sexual assault is an extreme form of sexual harassment. And the same laws that we discussed that protect Miranda from sexual assault in the workplace means that Miranda would still have a claim of sex discrimination against the employer. So if Miranda complained about the treatment, we know that we could show that the employer was on notice and is liable for failing to take corrective action to stop the sexual harassment. A lot of times, this is already going to be like the initial hurdle. Can we prove that the employer knew that this was going on? Again, it's not required to have a written complaint, but of course, having something in writing, it makes it easier to prove that the employer received information from Miranda that there was this harassment going on and they knew about it. But even if you don't have a written complaint, we can show other facts to show, or any other evidence. We could use different things to show that the employer knew about it. But we can also show that maybe there were things that demonstrate that the employer should have known about the treatment. We can point to maybe an instance if the supervisor was around during some of this behavior, or if it was so frequent and so obvious that the employer was aware of it or should have been aware of it. Okay, so even if Miranda has difficulties facing obstacles in establishing her sexual harassment claim, Miranda will also have a standalone claim for retaliation against the employer based on the employer's decision to terminate Miranda for engaging in the protected activity. Miranda does not have to prove that the perpetrator committed the underlying assault in order to have the right to pursue a claim of retaliation. Rather, that claim is just going to be to show that she engaged in the protected activity, which could be really just to say that the complaint itself to the employer is protected activity. In that because of that, the employer took a punishing action against her, which is considered an adverse employment action. So an adverse employment action, of course, could be terminating her, which the employer did here, but it could also be, as I mentioned before, transferring her when she actually was the one who needs protection in the workplace, demoting her or disciplining her, issuing her warnings when they aren't warranted, or changing her hours to avoid contact with the perpetrator. That can all be adverse employment actions. So the key here is then to show the connection between the employer's decision to fire Miranda with her taking action to protect her own rights to be free from a workplace with sexual harassment. So again, this is where it gets a little tricky. These are really fact-dependent cases. And generally an employer will bring up some other reason as the real reason that they're firing Miranda. And so we would have to take a look and really, if we can show that it was a determinative factor, that would help us at least draw the inference that the real reason is because of her taking part in protected activity. That's the real reason for her termination, and it was retaliation. So again, it's the timing, the proximity of how close in time the complaint is to the action is very like a helpful, highly relevant information. But just because you file a complaint of discrimination doesn't mean that your employer can't fire you at all for anything you do. It's of course, the timing of it is of course helpful information, and it can help raise an inference that the real reason was this unlawful act. So to pursue a claim of sexual harassment or retaliation, Miranda would have to file a complaint with an administrative agency, generally within 300 days of the events, and which administrative agency she would choose to pursue may depend on a variety of factors, including where the employer is located, the size of the employer, and what her goals are as far as like being able to quickly resolve the case, or where she would want to pursue litigation if the case ended up going to court. We did have a recent case with a client very similar to Miranda's before the EEOC, and we filed that charge of sex discrimination with the EEOC. In that case, we were able to resolve and successfully negotiate a settlement through mediation. But if we hadn't been able to resolve it that way, we would have been given a right to sue in federal court. Fortunately, in our case, we were able to resolve this fairly early in the process, and that meant our young client was able to move forward without having to go through these kinds of lengthy, invasive legal proceedings. And this was a particularly satisfying case in that, as Teresa mentioned, and as Micah's work highlights too, it's very difficult to go through this process. And actually being able to help our client kind of see what her rights were and to be with her alongside, it ended up being a really empowering experience for her to be able to stand up for her rights and to get a resolution and to see accountability in this case. Okay, so as I mentioned, there are a range of, I think we need to go back one slide, please. Thanks. As I mentioned, there are a range of, actually 2 slides. Can you go back one more slide, please? Okay. As I mentioned, there are a range of employment laws that at the local, state, and federal level that protect employees from discrimination and retaliation in the workplace. And I mentioned that there are a variety of factors that may influence where you would want to file. We are fortunate that in Illinois, we have a few expansions that are broader than what the federal government actually protects under the Illinois Human Rights Act. First, the Illinois Human Rights Act protects employees who work for small employers. So they can file a complaint. To file a complaint under federal law, you actually have to be considered an employee and work for an employer with at least 15 employees. In contrast, under state law, employees who work for just a small employer with even just 1 employee, they are still protected and have rights to be free to have a workplace free from sexual harassment under the Illinois Human Rights Act. So this change actually was fairly recent. It's less than a year old. It was put into effect in July of 2020. Second, state law also broadly defines workers to include employees and non-employees, such as independent contractors. So this is an important change, particularly given how our economy is changing and the growing number of workers who are not considered employees. Without this expansion under state law, a lot of people who are workers or freelance workers, independent contractors would really not be able to protect themselves from sexual harassment in the workplace. And third, the Illinois Human Rights Act also includes as an additional protected category those who have orders of protection. So we'll talk about an example of that. Okay, so as I mentioned, some of these changes are fairly new, and that means that a lot of times employers themselves are not particularly educated about these broadened protections for workers. So for us, that means that when we can learn about a violation early, there's room for us to advocate on behalf of our clients before they suffer from a destabilizing loss of employment. So one such recent example is the case of Paula. Paula was assaulted by her ex-boyfriend and coworker outside of work and was seeking an order of protection against him. Paula initially sought assistance from Legal Aid Chicago related to the emergency order of protection. Her ex was her coworker and her boss's brother, so she was particularly concerned about having to work in the same place as him or suffer losing her job. So the Children and Families Practice Group actually immediately identified that there was an employment issue going on here and referred the case to our team. So our team was able to speak with her quickly and learn that the boss was essentially offering an ultimatum, which was that he would demote her and require her to lose her management position and schedule to really limited days, or to quit her job. So our team was able to quickly write a cease and desist letter to the employer, informing and educating them about Paula's rights under the Illinois Human Rights Act and how their actions were in violation of her rights. So through that direct advocacy with their attorneys, we were able to get Paula restored to her management position and basically move forward and keep her job. So this was a great example of how we are able to collaborate to address issues. Okay, so we talked briefly, and Maria also talked about VESA. So VESA is the Victims Economic Security and Safety Act, and this is a really important law in Illinois that allows survivors of domestic or sexual violence or their family or household members to up to 12 weeks of unpaid job protected leave for the purpose of seeking medical help, legal assistance, counseling, safety planning, or other assistance. So this is a really important piece here because once Paula, thankfully she was able to keep her job, but she is still coping with the effects of the assault by the coworker, and she would now be entitled under this law to take time off to go to those counseling sessions and attend court dates. Last, I just want to highlight that Legal Aid Chicago does also provide immigration legal services to clients who are survivors of domestic violence or sexual assault. And our immigration team represents clients in their applications for U visas and VAWA petitions. So to really briefly summarize, a U visa really is a law that is designed to create protected status for those who are undocumented victims of certain qualifying crimes. So they have to cooperate with law enforcement. And so it's essentially allowing those individuals to find a pathway to get a immigration status that could eventually lead to legal permanent residence and citizenship, but largely contingent on cooperation with law enforcement. The VAWA is itself a law enacted called the Violence Against Women's Act, and that is to help undocumented survivors who have experienced domestic violence at the hands of their US citizen or legal permanent resident family members. So here it's because typically those individuals would be required to rely on the abusive partner or parent or spouse or in order to get lawful status here. So this allows them to self-petition. Here, there isn't a requirement that they cooperate with law enforcement. It's really more related to the relationship with the person, the legal permanent resident or citizen. So on a final note, I just wanted to say that insecure immigration statuses can make some of our clients particularly vulnerable to abuse, while being also a deterrent for clients to enforce their rights. So Legal Aid Chicago's ability to provide support through the very long process of obtaining immigration relief is a very important part of providing comprehensive legal services. So I will now turn it over to Micah to briefly talk about public benefits and consumer rights needs.
Hi there, can you guys hear me? Did this work? Okay, yes. Hi. Okay, I'm just going to be very brief because I know we have a lot of questions and we definitely want to get to everybody's questions. So, as Teresa had said earlier, I don't directly work in public benefits consumer, but when those types of cases come up with a sexual assault survivor, I have the honor of co-counseling with my colleagues in these groups to work on the issues for our clients. The two main statutes we work with, which Maria had referenced earlier, are the Crime Victims Compensation Act and the Sexual Assault Survivors Emergency Treatment Act. With crime victims compensation, all victims of crime, including sexual assault, are able to apply for monetary assistance from our state government. If they're denied by the Attorney General's office, we can represent them in administrative law hearings, and we have done that. As for SACETA, it's a law that says that all medical costs are covered after a sexual assault and related to. So even if you need follow-up care that's not immediately after the sexual assault, that is covered under our state law. Sometimes medical places forget to enact that coverage, and so sometimes people get bills. In our example case with Beverly, she got a medical bill for her treatment after the assault. And as Maria said, you know, the advocates can try to get rid of that bill, but if that doesn't work, then our attorneys can step in to handle that. And one of our case examples that we had recently is a client who had to be taken by ambulance to the emergency room for her sexual assault, and she was charged with an ambulance bill, even though she wasn't supposed to. And I sent a demand letter and we were able to get that waived, and then also made sure that her credit score hadn't been impacted by that wrongful billing. Some other things we've done, you know, because it's not always under a particular statute or it doesn't always follow a straight line, is we recently had a client who her dad was physically and sexually abusive to her while she was a minor. She's now in college, and he added her to his health insurance. She did not want to be on his health insurance. She tried to get herself removed and the company wouldn't do it. We were able to send a demand letter to the insurance company and get her removed because she did not want to be associated with her father anymore. We also had an interesting case where a school was refusing to give our client her college diploma. She had been sexually assaulted by the athletic director while a student, and her grades had suffered, and she failed a few classes and needed to retake those classes through summer school. The school was refusing to give her her diploma because she hadn't paid for those summer school classes. Well, our position was she never should have had to pay for those summer school classes because the school should have been offering her accommodations under Title IX and a few other laws that colleges have to follow. And so we were able to get her diploma back for her. So these are just a few of the interesting and unique cases we've had in public benefits in the consumer world. Lots of other examples, but we don't have time to go fully into everything today. I'm going to turn it over to Teresa right now to talk about some housing law protections for our clients.
So briefly, because I can't do this work justice, and I know we're a little over on time here, I'm going to tell you about Legal Aid Chicago's housing work as it relates to sexual assault survivors, and especially the work of my colleague. I got to give her a shout out, Jackie Coriath, who is really the expert probably in the city on these issues. So we can help with a number of things. We can help with there are laws like the Safe Homes Act, VAWA, the Fair Housing Act, all of which provide certain protections for housing residents, whether it's private landlords or subsidized, and then the CHA has, you know, their own administrative rules. But briefly, under the Safe Homes Act, we can help with lease termination. So someone can just inform their landlord, let's say the sexual assault happened at the apartment, they want to leave, they can inform the landlord that they are terminating their lease, and that, if done all correctly, would be a defense to any lawsuit for rent in the future. We can also kind of take it to the next level. So for instance, an example being Beverly's case, if the housing authority employees did nothing, as they did here when she reported the handyman, We can bring a federal lawsuit with naming a number of different claims under VAWA, which requires, for instance, housing providers to adopt an emergency transfer plan, the Fair Housing Act, and we also have a number of state law claims on a case like that where the housing authority does nothing, and then Beverly is subjected to further harassment and abuse by the perpetrator. In those cases, you'll see claims for unlawful discrimination, negligence, or even constructive eviction. We have clients who, they try to tell the housing authority that that something has happened to them in their apartment, they need to move. The housing authority employees do nothing, and so they themselves just move out. They start couch surfing, etc., when really there are laws in place, there are protections in place that should be followed in order to help our clients maintain safe housing. Especially, we have so many clients who are particularly vulnerable because they rely on subsidies, and those subsidies, vouchers, etc., are not accepted everywhere, and so it's particularly difficult to find new housing for clients like that, and so they can be particularly vulnerable. I would like to turn it over to Melissa Pachola, who's the director of our volunteer services unit, and she's going to tell you a little bit about pro bono opportunities here at Legal Aid Chicago.
Thank you. And, hearing you all speak about how tirelessly you are working to assist these survivors is just truly inspiring. So thank you so much. And for those of you who might be interested in working alongside us, I'm going to highlight some of the ways you can get involved in Legal Aid Chicago's work and serving our clients. So at Legal Aid Chicago, we have over 20 different volunteer opportunities across the agency. And we've got everything from a time commitment of a few hours to a longer term representation. We have transactional opportunities and litigation opportunities and opportunities for attorneys and non-attorneys. You heard Micah in particular speak about the importance of getting a protective order to be able to assist survivors. And so many people need help, and you can help by representing someone to get an order of protection or another type of protective order. This is great hearing experience. The cases are typically not long-term, and Legal Aid Chicago will co-counsel these cases with you. So you can use your skills to help make a huge difference in the life of a client. We really can use your help to meet the needs of our clients in this project and many others. And you can find more information about all of our volunteer opportunities on our website. And you're welcome to reach out to me with any questions that you might have or about any of our opportunities and how you might be able to help. And I'll turn it back over to John Gallo now.
Thank you, Melissa. And just to wrap up here, thanks to you, Barthy, Micah, Teresa, and Maria for sharing your work with us and about your work. That concludes the planned content portion of our presentation today. In a moment, we'll start responding to the questions raised in the Q&A section. Before we do, a quick reminder, we'd appreciate it if you'd fill out the brief survey about the presentation. To do that, or if you'd like CLE credit, click on the link in the chat and fill out the form. It's a short form and it's very easy to do. Note that the certificates of attendance will be sent out within a few weeks of attending. If you don't receive one, just let us know. And please join us next week for our session discussing the needs of families living in subsidized housing. So the panelists have remained and will remain to answer your questions, which again, you should put in the Q&A at the bottom of your screen. And Melissa is our fielder of questions and assigner of answers. So Melissa, take it from here.
Wonderful. Thanks so much, John. And we do have a number of questions, and I can guarantee we won't get to all of them, but we'll get to as many as we can. So we talked a little bit about Miranda, and to be clear, Miranda was a minor. And so two questions related to that we're hoping you can address, which is, when parents and teens vary in terms of how to proceed legally, whose view prevails, and is there a ethical guidance for that particular situation?
I think Micah was going to take that one.
Yeah, I can handle that one. So it depends whether we're representing the child or the parent. There are different instances when we would represent the parent as opposed to the child, a little bit too complex to get into. But for most of my cases with protective order and education, I represent the child and not the parent. So from the get-go, both the parent and the child understands that I am representing the child's interest and what the child wants. And so when there's a disagreement about strategy, I go with what the child wants if the child is my client. Now, if in the rare cases where I'm representing the parent and the parent and child have a disagreement, I'm going to go with what the parent wants. So it really just depends, but we do try to make clear from the get-go, if we're representing the child, that we are representing the child and we need to put their needs first. And this is really important from the standpoint of when somebody's been sexually assaulted, they need to be given choices. They need to be able to make their own choices because choice was taken away from them. So to the extent possible, we really try to put the choice in the child's hands, again, as long as it's age appropriate and that's actually the person we're representing.
Great, thank you. And Micah, in particular, you mentioned a civil no contact order. Is there any option for someone if to get a civil no contact order if they don't know the identity of their abuser?
It's funny that you asked that because we actually just had this question come up in a case. It's a kind of complicated answer. I guess the short answer is no. You definitely need someone's name to file this type of lawsuit, to file any type of lawsuit. There is an Illinois Supreme Court rule where you can initiate a case against a John or Jane Doe and then try to use that case to get discovery to get the name. But when we have this situation come up, we just try to do our best. We have some pro bono investigators, we have access to Lexis, and we just try to do our best to find the person's name, also trying to work collaboratively with the police if they're involved. But the short answer is no, you really can't file this order because the court doesn't know who they're giving you protection against, and the sheriff won't know who to serve to warn that person that they can't contact you.
And then Barty, this is a question for you about if someone faces sexual advances by a potential employer and coworkers, is this something that we would typically take, and how would you approach a case like that?
Thanks for the question. So if somebody contacted us with that situation, we would likely talk to them about what their rights are in that case. We could advise them about potentially what they could do, what the employer could do. Typically, when we give them that information, at this point, it doesn't look like a violation would have happened yet. So we would, like my own approach is definitely to help understand the situation that they're in, but with acknowledging the fact that legal rights are one piece of the puzzle. Sometimes there are other considerations that people have in making choices about their employment and their future. So we would probably advise them, and then if there were, we may ask them to contact us again if after certain things if they happened in that.
Thank you. And I think Teresa, this might be something in particular that you could speak to. So what protections are available to ensure that orders of protection or civil no contact orders are enforced, and if they're not, do the filers of these orders have any remedies?
Yes, so often say it's only as strong as the person's willingness to enforce it. But if you have an order of protection, you have a civil no contact order, and someone is contacting you, they're violating the order, you can take that to the police, make a report, and then sometimes the state's attorney will then take that and prosecute it as a violation of the order. However, if the police officers, or if that part of the process fails, if the state's attorney part of the process fails, or there's a reason that they cannot give you the relief that you need, you can also take this back to the court that gave you the order of protection, file a motion asking that the person be sanctioned, including up to going to jail for their violation of the order. So you have options, and it really depends on which remedy you're trying to enforce. But yes, the order of protection is most powerful when you engage with those options, like going to the police, going to the state's attorney, and some self-help if those entities cannot help.
Great, thank you. And we've got a question about the Title IX case, which is such a fascinating area of law. And as you pointed out, Micah, so many of us think that it's just about soccer. So can a victim prove a Title IX case by establishing the educational institution's refusal to provide reasonable accommodation without proving the educational institution was responsible for the initial attack?
Yes, that is very possible. Unfortunately, we didn't have time to go into the detail that Title IX deserves, because there's really a lot of nuances to it and a lot of interesting takeaways. But yes, these cases against schools are about the school knowing about it and then not responding in the proper way. So yes.
Great. And then Barty, can you tell us what kind of monetary remedies might be available for someone who's a victim of workplace retaliation after they are wrongfully discharged?
Sure. So depending on the facts of the case, you would get maybe back wages, back pay for the time that you were not able to be working. You could potentially be eligible for other types of damages related to, like if there was like severe emotional distress or anything like that, we could get that. And then also, depending again on the facts of the case and what the allegations are, there may be an opportunity to get punitive damages. Typically, those would be later on in a litigation if you're in court. Those are sometimes, some of those things are harder to get, but we definitely seek to get the back wages and kind of things like that. And there's penalties as well under different laws. So, and then they are entitled to like attorney's fees and things, but in general, there's a range of remedy, like financial things, financial remedies.
Thank you. And this is a question I think might be appropriate for Maria, which is, can a survivor seek medical attention without getting law enforcement involved, therefore, in other words, not reporting the incident?
Yeah, that's a great question. Survivors absolutely can seek medical attention without being involved with law enforcement. So Illinois state law requires that medical providers notify law enforcement that they're treating a victim of a violent crime in the ER. So that's only a notification, meaning that the provider in the ER will contact CPD, Chicago Police Department, to say, hey, we're treating a sexual assault victim here. CPD will respond on site, but it is the victim's choice whether they want to engage with law enforcement. If they don't want to engage with law enforcement, they'll communicate that to their advocate or to the nurse, and then the nurse will communicate that to the officers. And the incident will simply be documented as a notification from the provider. Notification is simply, we're treating a patient who has disclosed sexual violence. So they absolutely can access care. They can access care free of cost. They can access the treatments that we spoke about. And in fact, I'll throw one in there. They can even do a kit without reporting the incident to law enforcement, but that kit would not be tested until they chose to report the crime.
Wonderful, thank you. And Micah, you spoke about parental rights issues, and there's a question here about, does the woman have to report the sexual assault at the time that it happened in order to get protections?
The answer is no. That's always going to be an issue that the other side can bring up. Like, you claim that you were raped, but you never reported it. But I think the hard part about it is that you have to prove the sexual assault happened by clear and convincing evidence, which the lawyers will know what I'm talking about, but for those on the call who are not lawyers, that's kind of the middle ground in between proving something beyond a reasonable doubt, which is really hard to do, and preponderance of the evidence, which we use in most of our civil cases. So, you can imagine what a challenge it is. A lot of these cases that are coming in, the rapist father is trying to get parental rights years after the sexual assault happened, and to the extent that the person didn't report to the police at the time, it's going to be a lot harder to come up with evidence. But the answer is no, it does not have to have been reported at the time. But if it was and the rapist father was convicted, you don't have to prove anything. If you have a criminal conviction, that is more than enough for what you need.
Great, and sticking with you, Micah, for a second on that case you talked about where our client was sexually assaulted, was many people are wanting to know, was there any disciplinary action taken against the 13 boys who were the perpetrators of the assault?
Unfortunately, there was not, at least not to my knowledge. Federal laws protect people's student records, and normally in sexual assault cases, you would be able to know if the school had made a finding against the boys. Our client was very focused on moving forward and what protection she was going to get at her new schools. We had to switch her a few times. So we never found out, we never pushed to find out what happened to the boys, but as far as I know, they were never disciplined.
Okay. We'll sort of wrap up very quickly, but Bharti, if you want to help us understand, when a person is not a sexual assault victim, but a victim of harassment or bullying by a same-sex supervisor, will you help?
So could you, if I'm understanding that right, so if they're a victim of bullying and it is based, so sex harassment can be with somebody from the same sex. It doesn't have to be of a sexual nature. But if it's not based on your membership in a protected class, then we wouldn't have these laws that protect us. And so there are some other potential protections depending on, again, like a lot of these cases are really fact specific. So when we do intakes, we try to have a broader umbrella and then try to understand like really what's going on in the workplace, because there are a variety of laws that could protect our clients, or, you know, when there is wrongdoing in the workplace. But if it's just classic bullying or somebody just doesn't have a liking to you, unfortunately, because Illinois is an at-will employment state, there may not be a protection for that client. But we always, I think there's a really large role in our advocacy to educate people about what their rights are in the workplace. And so even if there isn't something right now that they can do, you know, being more educated and empowered about what is and isn't appropriate in the workplace is really important.
Great. And I think we'll take this last question, which is, Teresa, can you talk a little bit about our income limits, particularly for those who are survivors of sexual assault? And if people want to reach us to be able to connect with one of our legal advocates, how can they do so?
Yeah, so income limits, we do have income limits for certain work that we do at Legal Aid Chicago, but these grants that we work under, a lot of these grants that we work under do not have income limits, meaning we serve folks at a variety of different income levels. So if you are a survivor of sexual assault, don't let it stop you thinking that you have to be like a certain level around the poverty level in order to be eligible for our services. You can contact Legal Aid Chicago by our main intake line is 312-341-1070. You can also contact our CLASP project, and you can reach us there at 312-423-5900, and or I'm just pulling up our email address. I believe it's just clasp@legalaidchicago.org, but I don't want to give you the wrong. Yes, it's clasp, CLASP, at legalaidchicago, that's all one big long word, .org. If you want to find out more about our services specifically for survivors of sexual assault, I encourage you to email that, and our special paralegal for this project will review your email and put you in contact with an attorney if it is a case in which we can help. So happy to take any. Thanks, Micah. And then Maria is also putting in the chat a link to Resilience's website. So if you are in need of services outside of the legal, civil legal needs, Maria, I'm sure her agency would be happy to speak with you about the services that they offer. So thank you.
Great. And so John, you can close us up.
Thanks, Melissa. As usual, a fantastic job. Thanks to our friends, to Maria and our friends at Resilience. Thanks to Jared and our friends at Catton, and thanks to the Legal Aid Chicago team. As usual, a 4-star performance. We've got an all-star team here and a great relationship with Resilience. So thanks for joining us, everyone. We'll see you next week.